Are you sure?
Mm.
I mean, did you want to talk to your, that was a long pause. So did you want to talk to your attorney about it more?
No.
I mean, I'm not going to be upset if that's what you want to do, right?
No, it's okay.
I just need to make sure you're clear with what you're doing. And if you're not, then I'll give you the time to think about it, send you back and let counsel come around and talk to you.
We have understanding.
You got it? You ready to do it then?
Yes.
Yes, sir?
Yes, Your Honor.
Sir's fine. You should hear what these people call me.
Yeah, they're ready.
You're not disputing the right of the police to stop you in this instance, are you?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital?
Yes.
Was there a blood draw?
Yes.
Did the results of that blood draw show the presence of cocaine and or its derivatives?
Yes. Yes.
And do you have any reason to dispute those results?
No, Your Honor.
All right. And at the time that you were operating that vehicle, was there a firearm in the vehicle?
No, it was in it was in the trunk. It wasn't inside the cabin with me, but it was in the trunk of the vehicle.
Okay, but you possessed that vehicle while you were under the influence of cocaine.
Yes.
Is that correct?
Yes, sir.
All right. I got messed up with everything.
Balenciaga.
I don't know why. Okay, I now have before me a plea form. Indicates that the defendant is going to be pleading guilty to disturbing the peace, a 90-day offense. Upon her successful plea to that charge, that count 2, count 1 would be dismissed, and the defendant is agreeing to forfeit the taser device. And also the prosecutor will recommend that she be sentenced under HIDA. That's the court's full understanding of the agreement.
Yes, Your Honor.
May I have her sworn? No, it's okay. No, I was waiting for you to take him out. I didn't know.
Raise your right hand. Do you solemnly swear to affirm you're about to give me the truth, the whole truth, and nothing but the truth?
Yes.
State your name, please.
Zakara Daphne Balenciaga.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail and a $500 fine plus court costs. Do you understand that?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're indeed guilty of this offense?
Yes.
All right. On October 17th, 2025, at the location at Gulfside near Clark Road, Pittsfield Township, Washtenaw County, State of Michigan. Where were you? Were you operating a vehicle at that time?
Yes.
All right. Did you get stopped by the police?
Yes.
All right. And at some point, the police discovered that you had a taser or something, correct?
Yes.
And what ensued or what happened from there, did that disturb the peace and repose of the immediate area surrounding you? Were you arrested?
Yes.
And the area outside of that arrest was a very calm and peaceful area. And that changed it when they were arresting you.
Yes.
Would you agree with that?
Yes.
All right. Ma'am, if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. Do you understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes.
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
April 8th at 9 a.m.
April 8th, 2026, 9 a.m. That is before me. Bond will continue. Okay, ma'am, on your way out, my probation department is located on the left-hand side of the hallway. Stop in there and just check in so we can start the process.
Okay.
Okay, thank you. There's like 50 billion public defenders. Pick one.
Stephanie Cannon on behalf of Ms. Glover. Ms. Glover, could you please state your name for the record?
Sakandra Glover.
Thank you. Not that one, but pick one.
When I spoke to her yesterday, Your Honor, she was not dressed.
I did a walk in.
What?
Walked in on an arraignment. I was unaware of that. So, Your Honor, we are asking for an adjournment of this matter.
So the nothing. I didn't do anything, but I guess it came off.
Okay.
I told my probation officer as soon as I got out of jail. I haven't done anything.
Your Honor, we're asking for an adjournment of this matter. I want to argue bond for her, but I don't know what her current circumstance and situation is to make that argument on her behalf. It's my understanding it came to her attention at some point yesterday that she had a bench warrant. She walked in.
I went to court on the 4th.
She walked in on the arraignment today for that process yesterday after we spoke, apparently. After we spoke, she walked in.
They let me know that I had a warrant at court.
I-
No, like when I went to court on the 4th for a review of my probation, they let me know that I had a warrant to come back in and have my daughter.
Why is she posted on this? Yeah.
I don't-
That yesterday, Ms. Glover was arraigned on a 14 probation violation. Her bond is currently denied. Her next hearing is on March 9th.
Bond is
So it's
tonight
for
on
that
that
day.
case,
Yes.
but she's posted on this case.
I've been done. My daughter.
What is the violation? She believes the violation is this case. Is that accurate?
I don't know, because
Okay.
that's not my
The violation is.
case. All I know is
They told me that
this case she's posted.
it's because.
So in this case, she's posted.
Okay, so I understand what's happened here, Your Honor. So for this matter, we're asking for an adjournment of this. My client was going to bring me some potential exculpatory information and evidence that she has that I was hoping to present to the prosecutor regarding this particular incident. Unfortunately, I'm suspecting that is now in holding and won't be able to get access to that until her 14B
When is that?
matter is
Do
addressed.
you know?
The violation is.
It's
Thank you.
Okay, so she's going to 14B Monday.
Okay.
So she's released on this case. So I'm just going to put this over to the 19th.
Thank you, Your Honor. We appreciate that. So it's not this case that you need.
Bond continued in this case. Thank you. Court calls the case of the People versus Cedric Blair. No relation.
On behalf of Claire, who's approaching. Claire, state your name for the record for me.
Cedric Blair.
I need you to sign this.
What are we doing?
Your Honor, this is going to be a plea. I'm just having him sign the plea form.
All the other. Yeah. Because they just.
Thank you, Judge.
Jesus. I now have in front of me a plea form that indicates that the defendant is going to be pleading to two charges. One, operating with the presence of a controlled substance, which I believe is the stated count 2. And also the possession of a firearm under the influence of stated count 3 upon those both 93-day misdemeanors. Upon a successful plea to those charges, counts 1 and 4 would be dismissed. I'm presuming, well, the sentencing judge waiver is not checked. And is he pleading guilty or no?
Yes, Your Honor, it's gonna be a guilty plea.
Those boxes aren't checked. Good.
What?
I stopped checking them. Every time I check them, I would. The attorney, because I don't know how to apply it.
You're absolutely right. That's my bad.
So I have that he's gonna plead guilty to those 2 charges. And then counts 1 and 4 would be dismissed. And this goes to Judge Barr. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That is correct, Judge.
May I have him sworn?
Right hand. You solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Cedric Blair.
Sir, it is this court's understanding that you're gonna be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Yes, sir.
First charge is a stated count 2 of operating with the presence of a controlled substance. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Court could order service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
Also, this court's understanding you're going to plead to the stated count 3 of possession of a firearm under the influence. That's a misdemeanor punishable by up to 93 days in jail, a $100 fine plus court cost, or $500 if the weapon was discharged or you were using the weapon. And also requires mandatory forfeiture of the weapon or device. You understand that?
Yes, Your Honor.
Also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, Your Honor.
You understand that, sir?
Yes.
All right. Still wish to plead guilty?
Yes.
Are you sure?
Mhm.
I mean, did you want to talk to that was a long pause. So did you want to talk to your attorney about it more?
No,
I mean, I'm not going to be upset if that's what you want to do.
no, it's okay.
I just need to make sure you're clear with what you're doing. And if you're not, then I'll give you the time to think about it, send you back and let counsel come around and talk to you.
We have understanding.
You got it? You ready to do it then?
Yes.
Yes, sir?
Yes, Your Honor.
Sir's fine. You should hear what these people call me. All right, sir. To the charge of operating the presence of a controlled substance, how do you plead?
Guilty.
To the charge of possession of a firearm under the influence, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form. Is that correct? Any question regarding any of those rights?
No.
All right. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I understand.
Yes? You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will.
That's correct.
And also because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
On the date of August 15, 2025, at the location of Lowell near Jarvis, City of Ypsilanti, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you ingested cocaine into your system?
Yes, Your Honor.
All right. And you knew what you were ingesting into your system was cocaine?
Yes.
Were you stopped by the police?
Yes.
All right. Why'd they stop you?
I actually don't know. Oh, yeah. Yes, she had to remind me, I'm sorry, that I had an outstanding warrant or whatnot, which is why they.
Okay, so they knew who you were.
Yeah, they read.
You're not disputing the right of the police to stop you in this instance, are you?
No,
All right. Were you ultimately arrested?
yes,
Were you taken to the hospital?
yes.
Was there a blood draw?
Yes.
Did the results of that blood draw show the presence of cocaine and or its derivatives?
Yes, yes.
And do you have any reason to dispute those results?
No, Your Honor.
All right. And at the time that you were operating that vehicle, was there a firearm in the vehicle?
No, it was in it was in the trunk. It wasn't inside the cabin with me, but it was in the trunk of the vehicle.
Okay, but you possessed that vehicle while you were under the influence of cocaine.
Yes,
Is that correct?
yes, sir.
All right. And you know that you are not to possess that while you're under the influence.
I didn't know that at that time, but I now know now. Like I thought, excuse me for explaining so much, but I thought as long as they were separate, like the ammunition in one compartment and the firearm in a separate one, I thought that was a safe way to transport. Now, as far as under the influence, I didn't read that far, so
That would be appropriate if it's a CCW charge, obviously.
Mhm.
Is that it's different?
Correct. Okay. Had you also been drinking?
yes, I had a little bit to drink about an hour beforehand.
Okay.
There's a BAC of 0.099, Your Honor, as well as THC and
Got it. Okay. And you're not disputing any of those results. Is that correct, sir?
No.
All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time that I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am not, Your Honor.
No, Your Honor.
And have I complied with the court rule?
If we're satisfied, Your Honor.
Defense is satisfied as well,
The
Judge.
court will accept the defendant's pleas of guilty to counts 2 and 3. Counts 1 and 4 are dismissed. Pre-sentence investigation and screening and assessment is ordered at 14A2. Sentencing will be
March 18th at 7 a.m.
March 18th,
Yes.
2026, 10 a.m. before Judge Barr.
Very briefly on bond, Your Honor.
Yes, sir.
Oh,
Ma'am.
mhm.
Sorry. My bad. I'm sorry. I just
Regarding bond.
told you that would upset you.
On bond, Your Honor, we are asking, actually, I should have looked exactly what my client's bond is right now. We're asking that the court allow him to have a personal recognizance
I
bond.
think it's a personal, did he mess up?
There was a
He did.
violation.
There was a
Judge.
violation.
And originally, the court had allowed for him to be released to an inpatient treatment program. I did inquire as to the status of that. The jail says they're just waiting on a bed to open up. I spoke with Mr. Natrib, so they don't have an expected date that he would be able to go. I've talked to him about the multitude of programs that are available. We're going to see if we can get him into Don Farm. He'd love to do inpatient. This is the gentleman that we talked about reuniting with his daughter. And so he's obviously had enough time to detox. He comes to court. He does what he's supposed to do, Your Honor. He is unhoused, which is part of the issue that he found himself in. However, which is why he'd love to do an inpatient treatment program. I think that we can absolutely get him involved in that. He's very much so ready and willing to do treatment. We just like to see if we can get him out, as the jail does not know when he'd be able to get placed into a program yet.
Any response? I don't, not as a punishment, I don't think I'm gonna change his bond. I'd like to see some assessment before any consideration of that, so certainly Judge Barr can do that.
Okay, it looks like the assessment had been completed. He just said that they're waiting for a bed to open up at Don Farm. I can get the details to the court. And I'm assuming that the assessment would have been to get him into an inpatient.
Inpatient.
Correct, Judge.
And my problem is that if I release him now, we're not gonna get him in. I mean, it's a catch-22, quite frankly. I don't know how he would get in. He's got a better shot, and this is such a strange thing to say, at getting into inpatient where he is right now than if I let him out, try to get him into inpatient.
Okay, would the court allow us to at least try to start off with the outpatient treatment program?
I'm gonna say no. I'm gonna say no for me. I will leave that to Judge Barr
All right.
to make that determination. I really think, I'm not doing this in terms of trying to punish him at all. I think he realized when he was here, he needs information. He knows that. And I know that. That's it. No, I understand what he wants to do, but so I'm going to deny the request at this time. I'll continue his bond.
Okay.
Certainly, all of that can be raised before Judge Barr.
Absolutely.
All right. Thank you. Court does call the case. People versus Enrique Davis.
In the very first plea, the judge carefully confirms that the defendant understands every right she's giving up, including the right to trial and appeal. That's not just routine paperwork. Legally, the court has to make sure a guilty plea is voluntary, informed, and made without pressure. Then the mood shifts completely with the confusion over bonds, warrants, and probation violations. You can actually hear how quickly things become complicated when multiple cases overlap. The attorneys are trying to piece together information in real time while the judge keeps the hearing moving forward. But the biggest moment comes during Cedric Belaire's plea. Notice how the judge pauses when the defendant hesitates before pleading guilty. That's important. Judges are trained to watch for uncertainty because accepting a plea from someone who seems confused could become a legal problem later. And when the firearm and drug charges are discussed, the defendant tries to explain that he believed transporting the weapon separately made it legal. The judge listens carefully but keeps bringing the focus back to one key issue: possession while under the influence. The final bond discussion is especially revealing. The defense argues treatment could help him rebuild his life, while the judge worries releasing him now might actually reduce his chances of getting into rehab.